Chang assures government has no intention of locking down businesses in Manchester amidst concern over curfew. National Security Minister Dr. Horace Chang has assured that the government has no intention of locking down businesses in Manchester. This amidst recent mixed reaction to implement curfew in Manchester. The enhanced security measures were imposed following a mass shooting at the Mandeville Market. Some councillors have questioned the rationale behind the curfew while arguing that the measure is stifling economic activities. Speaking during a tour of the Mandeville Market and surrounding communities, including Albion and Knockpatrick, Dr. Chang noted that the curfews were warranted as Manchester saw an unusual increase in murders. He stressed that the curfew imposed have proven effective in restoring order. Dr. Chang said that the curfew has helped in the apprehension of perpetrators involved in criminal activities. Manchester has recorded 42 murders since the start of the year. That is a 23.5% increase over the corresponding period last year. The minister has pledged to deploy more resources to the parish to combat the increase in murders. Jamaica on track to receive record-breaking 4.3 million visitors this year. Tourism Minister Edmund Bartlett says Jamaica is on track to receive a record-breaking 4.3 million visitors this year. He says this will result in the earning of US $4.5 billion, which would also be the highest in Jamaica's history. According to Mr. Bartlett, this year will be the first year the tourist arrival across the world will match pre-COVID-19 levels. He said Jamaica will be part of history making. He remains optimistic that next year Jamaica will receive 5 million visitors and earn US $5 billion. Mr. Bartlett was speaking at the Sandals All Mega Jamaica Showcase event.
In 2019, 1.4 billion people traveled across the earth for touristic purposes and spent 3 trillion US dollars. And then COVID came and all of that was eviscerated and we went to zero everywhere almost. And since COVID, the recovery has been so strong, but not complete until this year, 2024, when the world will see 1.5 billion visitors traversing the world and earn 4 trillion US dollars. And Jamaica, because of you, will make new records too. Small increment, but it's important over last year. We're going to close at some 4.3 million visitors, the highest in our history, and earn 4.5 billion US dollars, the highest in our history.
SSL trustee report to be resubmitted. The Financial Service Commission FSC and trustee of Stocks and Securities Limited SSL, Claudian Campbell, have arrived as a middle ground on the contents of the trustee report to be presented in a meeting for creditors and claimants on October 25th. Campbell had been required to prepare a trustee report by Justice David Batts after he was restored to his role at the end of May, with the report to detail the state of the company. That report was submitted on September 25th, a day before the opening court hearing. The FSC, through its new attorney, Simone Mayhew, had opposed the publication of the trustee report in its existing form based on what it has claimed at the point of time. After nearly 3 hours of deliberation, Mayhem and Campbell's attorney, Caroline Hay, were able to break in the impasse with Campbell to edit the existing report into a format that more aligned with the regulation of the Insolvency Act. That edited report was to have been made submitted on Tuesday, with a 2-hour hearing to be held Thursday to discuss, among other things, whether the FSC has any new objections to the edited report. It is not just a complainant about systematics, my lord. This is a report he wants to send to the creditors. That is why, my lord, we are vehemently opposing for a report in this form to go to the creditors. But we also say, my lord, that the report to the creditors is an entirely different report, Mayhem said in her opening remarks on the trustee report. The FSC has requested that the trustee's report be sealed at September 26 hearing due to its concern about the presentation of the report. That was based on the perspective that the report goes beyond the scope of certain subsections of the Companies Act and, if possible, erode in trust and financial sector regulator. The senior attorney delved into different sections of the report while giving verbatim from different cases in other jurisdictions to make reference to different sections of the existing Jamaican regulation. I will accept that there is certain an overlap of what would be in the report to the court, and it is that it would be the report of the creditors. Again, my lord, it is the manner of the presentation and certainly that the trustee has provided to the court in much wider than what is contained by Section 39 of the insolvency regulations. So whereas, my lord, some of the information is the same, we will say that certainly, or currently prepared, this report by the trustee provided to the court would offend Regulator 39. And given the way that the information has been presented, my lord, we contend that it would certainly, as presented, mislead the creditors and would not be in the interest of the bankruptcy estate, or certainly not in the interest of justice. May him explain regarding her perspective on the report. Section 233 of the Companies Act discusses the trustee's report and requirement to a submitted preliminary report to the court, while Section 39 of the Insolvency Regulators of the Insolvency Act also addresses the preliminary report to be submitted at the first time creditors meeting. While both sections address the trustee's report, the interpretation and application were both debated by both senior attorneys. Hay presented in her remarks that the different sections of Campbell's initial report were in compliance with the different subsections of Section 233 of the Companies Act. She also questioned the practicality of the FSC's request for there to be a second report to extract certain parts they weren't in agreement with. This was based on the consideration regarding additional costs to incur from a splitting report when the first creditors' meeting was not yet to be heard. Given the current circumstances and applicability of the court's order, the determination to be made at the priority and sufficiency, not style and presentation, is to be determined with reference to both Regulation 39 of the Insolvency Regulations and Section 233 Companies Act together. Given the imperative of the court to do practical justice, we would submit the other better approach would be that we look at both the content of Section 233 appears in the final report and whether the content of the Regulation 39 also appears in the final report. Bearing in mind the court's earlier observation that it is the creditors that are in the driver's seat, he questioned in the discussion on Campbell's report. But eventually mentioned the Bob Marley case, which eventually reached the Judicial Committee of the Privy Council, and how the trustee should be mindful of any situation and not to be proponent. With respect to Campbell's application regarding management fee, he refused the application until the first creditors' meeting was held. Once that meeting was held, he could review the decision regarding those fees, which are likely going to be used to satisfy the fees. Hay and Terence Campbell Wong of Carlin P. Hay, attorneys at law, represents Campbell. Mayhew from Mayhew's Law represents the FSC. An attorney from the Office of the Supervisory of Insolvency, OSI, observed the proceedings. Remember to subscribe, like, share, and click the notification bell for daily updates.